Comprehensive outlook given by Stuart McCarthy. We're moving, diving a bit deeper into the Maltese regulations and other jurisdictions as well. But we will start from Malta as we are in Malta. And I would like to ask Luke first, how does the general regulatory landscape for tokenized securities look at Malta right now?
So I'd like to thank Stobox for the invitation, and good afternoon to all. Well, the global regulatory landscape for STOs as opposed to ICOs is somewhat more certain, in the sense that STOs are going to classify as securities under existing legislation. Now, the current global status of such offerings can best be described in three approaches taken by different jurisdictions. On the one hand, you have jurisdictions which haven't yet taken a position on the way in which such offerings will be regulated. On the other, you also have jurisdictions which have deemed outright that they will be falling under existing securities laws. And finally, you have jurisdictions like Malta who do agree that such offerings fall within securities laws, and in this case also EU laws, because we do fall under the MiFID directive and the prospectus regulation. But Malta and the MFSA do believe that you cannot simply apply existing regulation from its very basis. You have to update this regulation to cater for new innovation. So what the MFSA have done is that they've issued a consultation paper recently, it was I believe in July, to consult the industry on changes to the existing framework to cater for tokenization. So, for example, one issue which does concern security offerings is the transfer of shares in a digital platform. In this aspect, the MFSA is proposing to make amendments to our Companies Act in order to cater for such innovation, as well as update existing laws to enable such transfer to take place on a decentralized basis. They've also dealt with corporate governance, so we've just had, for example, the chairman of the MDIA talking about system audits. It will now be a requirement in the investment rules to have such audit and to have the board directors of the issuing company take responsibility for such audit and obtaining such systems audit. One other issue which they touched upon, which is still somewhat unclear, as we all know, STOs, one major issue is the lack of a secondary market. Now, the NFSA is considering whether to have these STOs eventually placed on decentralized or centralized markets, because both come with their own issues. And I mean, the industry has given its feedback on this matter, and we do wait for the feedback document, which will be issued now, I believe, in the next 2 weeks from the MFSA. So essentially, Malta will be carrying out updates to its existing legislation. It won't be simply recycling MiFID regulation to cater for such innovation, but it needs to update it in order to meet the challenges posed by innovation.
Thank you. And Paul, who's here with us today, actually has written a thesis about the regulation of virtual financial assets as a payment method in Malta. And I would like you to comment in this regard. What is your opinion on the topic of digital security?
So, the virtual financial assets framework here in Malta was born out of a realization by the Maltese regulatory authorities that crypto assets brought with them certain similarities from the traditional securities market, but also had some kind of new aspects to them which we were not familiar with. And they realized that there were crypto assets, which obviously not all, I mean, they are the utility tokens, then there were crypto assets which fell strictly within the securities characterization, and then there were what we have termed virtual financial assets, which kind of have the certain hallmarks of a traditional security in which people could invest money and expect some kind of return or possibly lose their investment, but at the same time didn't fit squarely within the definition of traditional securities. And they decided to regulate that space. And we've termed them virtual financial assets, and they're basically crypto assets which have been regulated as an alternative investment asset. And while I think that's a great step in the right direction by Malta, what I sort of noticed with a lot of the queries that we were receiving at our office is that it didn't take into consideration those crypto assets which were created and intended to be used as a means of payment. So it still left a gap within the regulatory framework for what we call stable coins colloquially. And I felt that needs to be addressed still, because there's a gap. The rules that we've created for VFAs don't actually make sense in the context of a stable coin. So we still need to address this, and I came up with some proposals on basically how we can look at the electronic money directive of the EU to try and adapt some of the provisions towards this technology.
Thank you, Paul. Borys, and Luke just mentioned in his answer that he cannot apply existing regulations completely to digital securities. But as we have seen that not all regulators have taken exactly this approach, so I would like to ask you to touch upon what are the main categories, how do different regulators approach this question?
Probably it depends mostly on the type of law system adopted by the country. So there is different approach in the common law that adopted in the US, UK, the Canada, and in the continental law systems such as Malta, Germany, Liechtenstein, and other countries. So what are these differences? In common law systems, it is more flexible in the sense that the phenomenon is not regulated before it emerges. The phenomenon emerges, then there is a case in the court or which happens, and after that, dependent on that decision, the guidelines are adopted. So in such sense, the emerging financial innovative assets have more flexibility to be adapted in common law system, because you just issue them. You can have your opinion on how they should be regulated, and then you see, dependent on how does it work in courts, how does it work in the cooperation with legal authorities for how they should be regulated. So you don't actually need to issue new legislation, to go through parliamentary process, through perhaps years. It is simpler on Malta, but in the US it may take very long time to actually create a law that would govern new innovative digital securities. So in such system, the guidelines issued by court after the decision or by regulatory authorities is enough to create a legal framework for securities to exist. And on the other hand, you have the continental framework, the EU framework. In this framework, for something new to emerge, it firstly has to be regulated. So before the regulated is created, it exists in this gray area where it may be and may not fall under any actually law existed in all. That is the reason why most first STOs were conducted in countries with common law systems such as the US, and only now they are emerging in Europe. Although an interesting thing to notice is actually there are different approaches to how the DLT-based assets should be regulated in different European countries, which may create problems in the future in terms of capital markets union. So there are different classifications of digital assets in various European countries. In some countries, such as Switzerland, which is not in the EU but in the European area, you have the most popular classification of payment tokens, utility tokens, and security tokens. On Malta, you have DLT-based assets can be one of four types. It can be either virtual financial assets, it can be financial instrument, and our vision is the Digital Securities are MiFID regulated financial instrument. It can be so-called virtual token. That is a token that has value only inside some system but not outside it, and the electronic money. So there is different classification in Malta. And then you have new legislation in Liechtenstein, when you have a token container model which take another approach. So it is problematic considering how closely do different European countries work. And it actually undermines efforts of European regulators to establish capital markets union, because now you have a single asset which can be regulated in one way on Malta, and then when it is purchased by Liechtenstein investors, it may be regulated by totally different legislation and change its legal status. So we believe there is a wide range to go in order to synchronize on the EU level the legislation of DLT-based assets, and that is where Malta can also contribute by its framework. So continuing it, the reason why we go with digital securities and why we want to be regulated under MiFID and not under VFA Act or anything like that is that it brings legal certainty. Because to issue MiFID compliant digital securities, you don't need to wait for the EU to adopt laws governing DLT-based assets. You don't need to wait for Malta, for Liechtenstein, for Germany to change their legislation to adapt to the EU level legislation. You can go with the legislation that already exists. So this is the approach we are taking. Also, another thing I want to note in this point, if I still have time, so it's about the dichotomy of common law system and continental law system, and it's not actually the dichotomy, and there are other approaches. So for example, an interesting approach to look is the Japanese approach. So what you get, you don't have a legislation on the country level. You have country establishing self-regulatory organizations such as professional unions, creating rules for STOs to be conducted. So if on Malta you get MFSA proposing a framework, issuing consultation document, then getting feedback from the professional community and issuing the legislation, on Japan they basically, as far as I understand, just outsource creating rules to actually the market participants who know the market the best. So there are different approaches for this, but as the world is moving further, and as accounting of all types of securities and financial assets is moving to the distributed ledgers, as Switzerland, Malta, London Stock Exchange are building DLT-based framework for accounting assets, we will probably need more framework for synchronization of different legislation to promote globalization and free cross-border trade to promote economic growth.
Thank you, Borys, for this very comprehensive analysis. And to wrap it up, I would like to ask Jean to summarize what are the specifics actually of conducting a digital securities offering in Malta.
This specific is basically to comply, and there's another issue about regulation. Another issue about the regulation is not only what are we regulating, is that the old business model is up to regulation, or is technology bringing a new business models which have to be regulated? Because when you talk about digital securities, there's an absolutely way of eliminating brokerage, because this is our technological part. The zero time settlement allows a new way of actually conducting the whole business. So I think the regulation is not about how you change the old system gaming, but how you use the technology and understand the technology and regulate the new business models, but would be more efficient, more effective, and would be beneficial for the country. So I think that's the main aspect of regulation, rather than just simply looking back and taking up to a new technology.
And now let's go a bit more into detail. So a lot of companies who want to do STOs, they are looking into complying with a certain exemption, so to not be obliged to publish a prospectus. So looking at Paul, I would like to ask you to touch upon the European laws. So what is the situation with exemptions there?
For starters, I'd also like to mention how Malta's STO consultation document is dividing STOs into two categories. On the one hand, you have traditional STOs, which is basically tokenized equity, tokenized debt, like derivatives. But they've also made a provision for other STOs, which I believe Borys had mentioned in the first panel, which give dividends, but stop at that, the profits, and stop at that. The MFSA is considering whether these STOs should fall within the existing XTO framework, and they will be using their regulatory sandbox to try and come out with legislation in this aspect. So, in regards to exemptions, it could be that these types of STOs will be subject to less rigorous requirements, but on a general basis, exemptions come from the prospectus regulation, and these are clad in law, and you have basically instances when it's a private offering. So, for example, it's issued only for 150 persons. When it's offered to qualified investors being experienced investors who invest certain amounts of money, or experienced companies or banks, those would be exempt from a prospectus offering. And then the EU prospectus regulation does set a threshold for offerings, and it's up to the member states then to determine the amount of funds raised in 12 months which merit a exemption. Malta has gone with 5 million, and
Malta has gone with 5 million, although the prospectus regulation provides for 8 million. So obviously we are trying to push back to budge that up, but I understand that the MSA is in the process of updating the Companies Act, so hopefully that is something that would be taken on board, because I believe it would be very attractive to in the industry. If I could touch on what Luke started with as well, on the STO side, it's an interesting point about the profits, because we've seen a lot of STOs, it's called in that, where the promise is not dividends as is traditional, but a portion of revenue, which if you run the financial instrument test that's been created under the Virtual Financial Assets Act, would classify the instrument as a financial instrument, even though it doesn't satisfy the definition under MiFID of a transferable security. So we've created a kind of conundrum. So hopefully this, will be addressed with the STO regulation. And there are other exemptions when either the nominal value of the security is 100,000, or when the minimum investment, despite whatever the nominal value is of 100,000 for the investor.
We're talking as well about the prospectus. The existing prospectus, as it applies to securities, does need fine-tuning when it comes to STOs, because we need to disclose information about the security, the technology arrangements, for example, about smart contract auditing. So what we're expecting in these new rules now to be issued on STOs is certain, when an STO does need a prospectus, what type of disclosure is needed. This, I believe, they can draw inspiration then from the VFA Act, where they've listed the particular disclosure provisions required for token offerings.
No, in fact, that's the quagmire we have at the moment. So a VFA limits an investor to a €5,000 investment. And then you have if you run an STO currently, legally speaking, there's no cap on what an investor can invest. And yet the technology that's supporting the raise would not even be audited. So the safe raise actually has more stringent requirements at the moment.
I can talk from professional experience as well. We've had STO prospectuses to draft, and we've had to, try and draw inspiration from white papers to, try and combine them with the traditional security offering document, to create something which is presentable to the authority. And basically, we do need now guidance from the MFSA in this regard.
Yeah, I think now our time is up. Yeah, Borys now. Okay, gentlemen, thank you so much for this very comprehensive panel.